Hi, everyone. Good afternoon. This is Mary Rasenberger. I'm the Executive Director of the Authors Guild. And here with me at the Authors Guild is Ryan Fox, who is our Director of Policy. As Casey said, we're talking about First Amendment issues. We will be doing a survey of contemporary First Amendment issues today. Before we start, I'm going to read the applicable parts of the First Amendment that we're talking about today so that everyone knows what we are talking about. It says, Congress shall make no law abridging the freedom of speech or the press. That's all it says. Now, the First Amendment also relates to establishment of religion, and the right to peacefully assemble. But we today are going to talk about freedom of speech and the press. The rest of the First Amendment has been left to the interpretation of courts over the years, most importantly the Supreme Court, and we will get a little bit into the history of the First Amendment with one of our panelists, Chris, today. The new Trump administration and the media surrounding his election raised new First Amendment issues and certainly renewed interest in the First Amendment, particularly relating to freedom of the press and access of the press to, for instance, the White House and to government information. But in addition, as you'll hear from our panelists today, we continue to have challenges to free speech and some new free speech issues in schools, in school libraries, on college campuses, in publishing today, as well as in investigative journalism. So today we have an amazing panel of speakers who are some of the nation's top experts on these issues. We're very, very fortunate to have them. I want to thank them for joining us today. First, we'll hear from Chris Finnan, who's the director of the American Booksellers for Free Expression. Chris will talk about the history of free speech in the U.S., tracing the growth of free speech after World War I and the development of groups like the National Coalition Against Censorship and the Media Coalition, where our other panelists are from, these kind of groups that support the freedom to express ideas. Joan Burton, the Executive Director of the National Coalition Against Censorship, we'll talk about a survey they did on book censorship in schools and self-censorship by teachers and what kinds of books are most often challenged, and with some follow-up issues. David Horowitz is the Executive Director of the Media Coalition. We'll talk about the pressures on investigative journalism today, recent conflicts in the law that we've seen between privacy and speech, and recent use of tort law to chill speech. So I am going to turn this over to Ryan first to read our panelists' full bios so that you have the benefit of knowing their background, and then we'll start with Chris.
As Mary mentioned, we have three distinguished panelists with us this afternoon. They are Chris Finnan, Director of American Booksellers for Free Expression, which is part of the American Booksellers Association. Chris has been involved in the fight for free expression since 1982. He's the chair of Media Coalition as well, a trade association that defends the First Amendment rights of businesses. A former reporter, Mr. Finnan studied American history at Columbia, where he received his PhD. He's the author of From the Palmer Raids to the Patriot Act from Beacon Press, Alfred E. Smith, The Happy Warrior from Hill and Wang, and his forthcoming book is Drunks, An American History from Beacon Press this June. Next, we'll hear from Joan Burton, who's the Executive Director of the National Coalition Against Censorship. Joan is a graduate of NYU Law School, where she was a fellow in the Arthur Garfield Hayes Civil Liberties Program. After law school, she spent 7 years representing indigent clients as a legal services lawyer and more than a dozen litigating civil rights and civil liberties cases at the ACLU. She's taught at Columbia University, where she remains on the faculty, and at Sarah Lawrence College, where she held the Joanne Woodward Chair in Public Policy. She speaks frequently and writes on legal and policy issues, and she's the author of more than 30 chapters and articles in professional books and journals. And last but not least, we'll hear from David Horowitz, the Executive Director of Media Coalition. He's an expert on First Amendment law related to content regulation. He served as Executive Director at Media Coalition since 1998. Media Coalition, for those who don't know, was a trade association founded in 1973 to defend the First Amendment right to produce and distribute books, movies, magazines, recordings, home video, and video games, and to protect the American public's First Amendment right to have access to the broadest possible range of information, opinion, and entertainment. With that, I'll pass it back to Mary to get us started.
Okay, thanks, Ryan. So we will start with Chris, who will give us an introduction into the history of free speech in the United States.
Okay, Chris, thanks, Mary. Yeah, thank you. You know, I'm going first here in part, well, not because I'm an author, and the Authors Guild knows how to treat its members. I'm all paid up, my dues are paid up, and since I'm talking to authors, I'm sure you guys will forgive me for, you know, plugging my book, From the Palmer Raids to the Patriot Act, A History of the Fight for Free Speech in America. And I hope you all run out to your local independent bookstore and ask for it. Now, they won't know what you're talking about. It hasn't been on the shelves for years, but they can special order it for you. So, okay, the commercial part of this is done, and I've been chosen to speak first really because I'm going to give you some background on the history of the growth of free speech in this country, and that's the idea that free speech has grown is somewhat alien to Americans. I mean, we grow up hearing about the First Amendment and thinking that we've always had free speech in this country, and with the implication that, you know, we always will have free speech in this country, and what is there to worry about after all? But the fact is, there has always been censorship in America. Just a few years after the Founding Fathers adopted the First Amendment, the Federalists threw a bunch of Jeffersonian editors in jail for exercising the very freedom to criticize the government that presumably was protected by the First Amendment. So right from the beginning, there was uncertainty about how far free speech, how much free speech there was in this country. Throughout much of the 19th century, local law enforcement, which was pretty much the only law enforcement there was, state and local enforcement was used to suppress the free speech rights of people espousing radical views, people like the abolitionists who were often mobbed, their presses broken, and at least one abolitionist editor was killed. Congress refused to accept anti-slavery petitions from the abolitionists, and you can't imagine a more direct violation of the First Amendment than the government refusing to hear a petition. Besides the abolitionists, a little later in the century, advocates of equal rights for women, feminists, found themselves being prosecuted under the obscenity laws for advocating such things as equal rights in marriage, birth control, and other practices that mainstream America considered to be sexually deviant. The biggest suppression, though, the free speech suppression during the 19th century was undoubtedly directed at the labor movement. Union organizers found it sometimes impossible to meet, to enlist members in their unions, to picket, and often faced injunctions from the government that suppressed the right to strike entirely. So it was commonplace to censor in America in the 19th century, but it really didn't affect most Americans, so nobody really cared. The civil liberties meltdown, however, that occurred during World War I really was a turning point in this history. The Justice Department used the extensive war powers that had been given to it by Congress to deprive anti-war publications, socialist publications in many cases, the right to use the mails. They prosecuted people for speaking out against the government in any way. More than 2,000 people were indicted under the federal law. Almost 1,000 people were convicted, and many of them were sentenced to long terms in jail that affected them for the rest of their lives, even though most were pardoned at the end of the war. So the spectacle of a democratic country depriving its citizens of the most basic right, which is the right to debate the ability of the wisdom of the government engaging in war, struck a number of Americans who would become, the first generation of civil libertarians as wrong. And it's not a surprise at all that it was only a few years after the end of the war that the American Civil Liberties Union began in 1920. Even then, it was another 10 years. It wasn't until the 1930s that the Supreme Court protected free speech for the first time in a couple of cases. The major expansion, the period in which the number of protections for free speech were increased by the Supreme Court was actually in the 1960s as a result of the conflicts arising from the civil rights movement, which in the South faced a wholesale suppression of free speech, as well as the anti-war movement, the Vietnam anti-war movement. The one big exception in the 20th century to the growing rights for free speech was material with sexual content. It wasn't until the 1950s that the Supreme Court came up with a working definition of what was obscene, a definition that could be used to protect material with serious literary, artistic, and political scientific value. As late as 1961, 60 booksellers were prosecuted for selling Tropic of Cancer around the country when that first became available from Grove Press. So today, the fact that there are a handful of groups that exclusively defend free speech is really a fairly recent phenomenon. ACLU, of course, had a very broad agenda. It protects all civil liberties, including free speech, and it has done, obviously, very important work in protecting free speech. But it became necessary in the early 70s as an effort got underway to roll back many of the protections that had been passed in the 60s to create some new groups to defend, that would exclusively defend freedom of speech. The National Coalition Against Censorship and Media Coalition were both founded in 1973 as a response to a Supreme Court decision that we all feared would significantly undercut the protections that had just been established for sexual speech, and they have operated, through some heavy waters, some heavy periods of intense pressure. The 1980s, the culture wars of the 1980s were a time when both groups were extremely active, and they've gone on since then to engage in a wide range of other activities in defense of free speech in other areas. So one of the points I'd just like to conclude with is that we are, our organizations are defenders of free speech, of everybody's free speech. We are not partisan. We do not take sides. We don't look at the content of speech. We think there's enough work for us just to make sure that people have the right to say what they want and to give the American public the opportunity to make up their own minds about whether they want to endorse or oppose those ideas. So that is the history of free speech in 10 minutes.
Okay, Chris, thank you very much for that. You know, it's, I think, astounding to many of us that free speech, as we know it today, is so recent that it's really just began in the after World War I in the U.S., at least the way we think about it today. Now, the First Amendment, though, was in the was enacted back in, I believe, in 1790, right after the Constitution was adopted. So, Chris, can you just explain, for historical interest's sake, how did people think about the First Amendment prior to the 1920s and 30s? And were there any legal challenges defending the First Amendment, free speech, prior to the 1930s?
Well, I think it's fair to say nobody thought about the First Amendment very much. I mean, there was no litigation, before the 20th century, in support of First Amendment rights. Most people thought, saw government suppression as being directed against radicals who they didn't agree with, and they didn't see any inconsistency between the paper commitment of the Constitution and government cracking down against hotheads and people who threatened the corrupt morals of the public. So go ahead.
Yeah, no, okay, well, it's fascinating. I did want to just ask you, as you're with the American Booksellers Association, if you could just talk briefly about whether you see any increased First Amendment pressures on bookstores today or publishers, and what those are, if you do.
Right. Well, I think it's fair to say that there is an increase in censorship pressures in American society today. I think it comes from both the left and the right. There are people who are advocating for restrictions on speech that is hateful or directed against people in a discriminatory way. On the left, on the right, there's a feeling that the mainstream media, a rejection of the mainstream media as fake. I think both of these are, deeply troubling trends. But as far as it affects book publishing and booksellers, I think one of the things we're most concerned about is the fact that a number of books have been targeted for protests and have caused publishers to withdraw them from sale. In the last 18 months, there have been four books that were either delayed, canceled, or withdrawn as a result of protests. Birthday Cake for George Washington, which was a kid's book about George Washington's chef who was a slave. A book called When We Was Fierce, another kid's book. Bad Little Children's Books, which was a satire, a book of satire for adults, and of course Dangerous, the Milo Yiannopoulos book that Simon & Schuster has canceled. I mean, we are disturbed by these attacks, in part because we feel that whenever a book is withdrawn, it simply increases pressure on the next book that somebody finds offensive, and publishers are in business to make money, and they you know, they are subject to influence. They are influenced by protests. So we are concerned about that. As far as censorship pressure directly on booksellers, I'd say we're not seeing direct pressure on booksellers, but booksellers, like every other American, like all other Americans, are concerned about what's happening politically. The election was a shock to the country, and to many in the country, and booksellers included, and booksellers have been trying to figure out what their place is in this deeply polarized country. And they've come up with, you know, a number of different answers. Early on, they saw themselves, they offered themselves, many offered themselves as refuges for people who feared that their civil liberties would be under attack as a result of the change in administration. There were stores that were focused on encouraging political participation, holding seminars on ways to influence public policy. And there's also a growing interest in, among some booksellers, in promoting dialogue between the left and the right. So we are definitely, you know, responding to the challenges that that all Americans face, and you know, we expect to continue to play our historic role as supporters of the marketplace of ideas.
Great. Thank you, Chris. That I think describes the situation today very, very well, and it's a really good segue into Joan. I would like to, before we move on to Joan, I would like to just tell everybody that you should feel free to enter questions at any time. You just type them into the chat box, and we will be keeping track of them. We will take questions at the end. So thank you, Chris. We're going to move on to Joan now from the National Coalition Against Censorship, and she will talk about book censorship in schools and self-censorship by teachers, as well as the kinds of books that are challenged.
Great, thanks, Mary. And, you know, there's been a lot of attention to perceived assaults on First Amendment rights coming from the new Trump administration, but I'm going to talk about something that's very old-fashioned, which is book censorship in schools and libraries. And I like to say that censorship is about as old well, censorship is a fact of life. It has been with us probably since the first storytellers told stories around a campfire, around a fire, and the first artists drew pictures on the walls of caves. It's certainly been a fact of life ever since we have had a written word, and it is therefore, you know, just part of the background noise of society as people express differing views about things that are important in their lives. Notwithstanding that it is a constant feature of our work and anybody, in the work of anybody who's sort of involved with either education or First Amendment activities, but it's notoriously hard to document, in part because an awful lot of it happens sort of below the radar. So we have been, we track book censorship incidents informally, and the ALA makes an effort to track them as much as possible, although one of the things that we know is that most efforts at tracking book censorship are notorious undercounts. And one of the possible reasons for this is that a lot of these controversies are resolved behind the scenes. Another reason has to do with the fact that a lot of self-censorship happens sort of preemptively as a form of, a lot of censorship happens preemptively as a form of self-censorship. So in an effort to measure what the pressures are on public school teachers with regard to what books they use in their classes, we teamed up with the National Council of Teachers of English and did a survey of their members, and we got responses from approximately 3,500 teachers. And these are interesting. I mean, this is not a scientific survey, so because, you know, people were not required. We didn't do a sample. People weren't required to fill out the responses. So it's hard to say whether this is representative of teachers more broadly. But of the people who did respond, 42% reported that they were aware of a challenge in the last 5 years in their own schools. And that's a pretty significant number, I think. And it sort of corresponds with our experience, which is that book censorship challenges are quite common and widespread, even though most people don't know about them. When I tell people what I do for a living, they always say to me, what are you talking about, book censorship? We don't have any book censorship in this country. And I always say, yes, we do. Every day, someplace in this country, somebody is challenging or objecting to a book. The reason people don't know about it was also something that was hinted at in the survey responses, and that was that a very small percentage of these cases involving challenges received any media attention or any attention from outside groups. Only 7% received media attention, 10% received, or 9%, received attention from an outside group. So in point of fact, most people don't even know what's going on in a lot of these cases. In terms of the resolution, our respondents reported that 45% of these kinds of challenges were resolved by offering an alternative assignment to the affected student. And in some ways, that's a very, you know, that's maybe the best result, because it only affects that student, or we assume, we need to do some follow-up on this. If it means an alternative assignment for the entire class, that's a bit more of a problem. But in some 20 to 25% of the cases, books were either restricted or removed from the classroom, and that is a troubling piece of information, because it means that the sensitivities of some parents, or the preferences or the views of some parents, are driving what is taught in schools, and that is depriving other students whose parents do not object of the right to study material that teachers think would be valuable for them. Perhaps an even more interesting finding from this, from this survey, was the extent of what one can call self-censorship, and we could talk about how you define that. 61% of our respondents say they avoid either frequently or regularly books with sexual content. Another 55% avoid books that have profanity or vulgar language. And in an interesting finding, 63% report that they rely on outside rating systems like the Motion MPAA ratings and Common Sense Media and other similar ratings to decide whether or not to select a book for use in the classroom. From the narrative responses that we received from teachers, these findings aren't that surprising. I mean, teachers live and work, live in the communities, most of them in which they work. They know what the sensitivities of the parents are in the communities that they're dealing with. And like most people, they would prefer to avoid rather than court conflict. We see more veteran teachers taking more risks with regard to what they're willing to teach. And that, again, is entirely understandable. In our experience, I mean, this is not something that we asked about in the survey, but in our anecdotal experience and the experience of counterparts at organizations like the National Council of Teachers of English. The outcome of a dispute over a book often depends on the ability of the teacher to withstand pressure, on the support the teacher receives from school administrators, and on the respect and deference that school boards offer to teachers in their selection of educational materials. So I'm going to make a different kind of pitch than Chris's pitch for his books. School board members in this country are usually elected. So if you care about these kinds of issues, I would encourage you to consider running for the school board in your community. We certainly could use more school board members who care deeply about literature and about the ability of young people to access books and information that is of interest to them. Stepping back a little bit, what we see in terms of censorship conflicts in schools is pretty much a reflection of the anxieties and conflicts in the culture at large. And in our current moment, the cultural climate seems to have exacerbated many of these conflicts. We have always seen challenges, as Chris indicated, from left, right, and center. Take any book and somebody is going to find something about it that they don't like. Previously, maybe 10, 15 years ago, I would have said that most of the challenges that we were seeing at that time revolved around religion. The religious references in schools, people who felt that books offended their religious sensibilities or that they were inappropriate attempts to proselytize. And next, the close relative of religion would be morality. Politics and patriotism were also issues that attracted a certain amount of controversy. More recently, I think what we have seen, and this is not just in the school context, but in higher education and elsewhere, is that concerns about racial justice have helped fuel heightened sensitivities to racial issues in books and in education generally, and similarly, a heightened awareness of the problem of sexual harassment and assault has resulted in similar kinds of sensitivities to books that deal with that topic. So that is a very brief overview, and I guess as Chris alluded to this in his remarks, these sensitivities also drive pressures on authors and publishers. And the risk is that if these pressures succeed in chilling expression of views that are controversial, we're going to end up with not such an interesting selection of books on our shelves, and not a representative, and not a selection of books that represents the true diversity of opinion in this country. So I will stop there and invite Mary, if you want to ask me some questions now or hold them till later, that's fine.
So I did have one follow-up question for you right now, if that's okay. Because we do see some, I know we've spoken about this before, you and I, types of censorship and self-censorship on college campuses, where there are often disputes about offensive speech and, sensitivity triggers. Could you just talk very briefly about that?
Sure. Well, there's a lot of attention right now to the protests against Milo Yiannopoulos, Ann Coulter, and Charles Murray, and I just think it's important to remember that 15 years ago, the same kinds of protests were being staged against Ward Churchill, Bill Ayers, and Judith Butler. So again, this is, right now we seem to be in a moment where attacks are coming more from the left than from the right, but I think that is it would be misleading to conclude that or it would be incorrect to conclude that this is a sort of a partisan phenomenon. On both sides of the political divide and from places in between, there are these kinds of attacks on speakers on college campuses. The trigger warning issue, I guess, I assume that's what you wanted to get into a little bit.
Yes, thank you.
This is a little bit different, and it does reflect both a concern by students and faculty members alike to, in some ways, to shield students from unpleasant ideas. And it is for that reason that many academic groups like the American Association of University Professors have expressed serious reservations about the practice. I think what everybody many if not most teachers realize is that you're always calibrating your presentation to students to try to make the lesson resonate, say what you want, convey the ideas you want to convey in a manner that students can hear it best, learn from it. And, you know, some instructors use a kind of a shock approach, others do not. And there's room for a lot of different experimentation in that. And different teachers can be successful using different methods. So, you know, the AAUP's response, which I think is a wise one, has been to affirm the right of instructors to use techniques that they think best convey the material that they're teaching, and at the same time resist demands by administrators that they issue, let's say, trigger warnings for certain kinds of materials. So the AAUP would leave this up to individual instructors, and that seems to me to be a kind of a smart resolution. Some teachers will use them, some will not. In some cases they'll be effective, in other cases they won't. And then the whole question will sort of evolve with a little more evidence, fact-based evidence about what works and what doesn't work. The origin of the whole trigger warning issue has to do with an increasing awareness of the fact of sexual assault on campus and the fact that it was often not acknowledged on many campuses. And so, at least I think that it's a good thing to recognize when there's a problem that you've been sweeping under the rug. And so now the question is, how do you get to a place where you're recognizing a problem, the true dimensions of a problem, without undermining other important values in the way you do that? Does that sort of get where you wanted to go, Mary?
Yes, that's wonderful. Thank you, Joan. I think that's really helpful to understand the issues on college campuses in that light. And I do want to mention for those of you on the phone, if you're not aware of who AAP is, it's the American Publishers Association. And that advice sounds right to me. I do, Joe, have to make a pitch for a movie that, if anybody's interested in the issue of sexual assault on college campuses and how that's been swept under the rug, there's a movie called The Hunting Ground, which I think really helped bring that issue to the fore and bringing public attention to it. which I did a fair use review of when I was still in private practice before I came to the Authors Guild. And I heard the producer speak on it just last week at an event. Anyway, I do want to move on to David Horowitz, who's the Executive Director of the Media Coalition, and he will talk about some of the issues that they've been working on recently. So David, I'll turn it over to you.
Thanks, Mary. Thanks for inviting me, and thanks for everybody who's attending. Media Coalition does legal and legislative advocacy, which is, I guess, our fancy way of saying we do lobbying in state and federal and the federal legislature, as well as doing legal work by bringing challenges to laws that have been passed that we believe are violating the First Amendment, as well as writing friend of the court briefs. So I'm going to talk a little bit about, some of the issues we're seeing right now, and try to put them in a little context, in sort of a larger discussion. So the first, are some examples of pressures on investigative journalism, in particular citizen journalism, that's increasingly common, or maybe continues to be common, is a better way to put it. The first, obviously, is the threats to prosecute publication of leaked materials. This is an age-old tradition. It certainly has, there's been no abatement. The Obama administration, well, let me say, a lot of it focuses on national security issues, but is not limited to national security. The Obama administration was very aggressive in attempting to force reporters to testify and threatening them with prosecution for publication of classified information. And the Trump administration, everything they have said so far indicates that they are just as concerned about leaks and potential for chasing down both those who've leaked and those who've published the leaks. So that is, the sort of the way we think about this most commonly, but it's not limited in that respect. We spent a lot of time last year fighting legislation in California that was meant to punish anybody, criminally punish anybody who published the videotapes that were the undercover videotapes that were made, in a way that to make abortion providers look bad, and questions about whether fetal tissue is being sold. Now, there's no question you could prosecute somebody who illegally taped meetings without permission. There's questions of consent. In conversations, you have to have consent of the parties to record them. But in this case, the legislation specifically wanted to punish anybody who was not connected to the recording of the videos for publishing them. And I mean, that's, basically the same premise as punishing the New York Times for publishing the Pentagon Papers. So luckily, I can say in the end, we were able to get a bill that both sides could agree to that didn't impose any liability on publishers who didn't participate in the actual illegal recording. But it's an example of the concerns with leaked material, the concerns with illegally obtained material, and then being published. Another example along those lines is what we now call ag-gag laws, although they're not limited to agricultural production anymore. But they come sort of in three models. The first is anybody who records cruelty to animals must immediately turn their recordings over to law enforcement, who typically may be sympathetic to the ag producers, the large employers in town, and are not necessarily all that concerned with prosecuting the cruelty to animals. The second version, of which several laws have been passed, makes it a crime to obtain access to an agricultural or industrial property, record, and then release those recordings. We often see these recordings around, again, it's the cruelty to animals typically, but also you see it where there's undercover journalism in old age homes and other places like that, where there's concern about the treatment of the patients or the clients. There's laws passed in Wyoming, Utah, and Idaho. All have been challenged. All have been blocked so far. The Idaho law is now before the Ninth Circuit, and what happens in that case may dictate what happens in Wyoming and Utah. And now the latest iteration of this attempt to stifle undercover investigative journalism are laws that allow a cause of action. So if you obtain access by not being forthright on your application for employment, you gain access to the property, and you publish some recording that is harmful to the business, they can sue you for damages. North Carolina has a law that was passed. Arkansas just passed a law. And Arkansas's law included a provision that allowed anybody who aided, encouraged, assisted, or directed the person to do so to also be jointly liable. So it would allow, a lawsuit against the news publisher if, in fact, they paid for the tape, or they said if you get documentation of these violations of the law, we'll publish it. You could be deemed to have aided the production of the tape, which harmed the company and led to great financial damage. And then the third example along those lines is really the fight between the police and cell phones. A common practice is for law enforcement, when they've been videotaped engaging in behavior that could get them in trouble, is to seize the phone, delete the images, or seize a camera, as the case may be. And while you may think that the right to record police in public engaging in behavior while they're on the job is protected by the First Amendment, that's not a clear question. There's two cases presently before circuit courts, one in the second, one in the third. Authors Guild was a signer of an amicus brief in the Second Circuit, along with a number of members of Media Coalition. But that's an open question, and the courts are now moving in the direction of saying there is a right simply to record, and that you don't have to be, engaging in journalism to do so. But it's a fight that is ongoing and is certainly not a clear legal question at this point. In the next area, that we see as sort of an, as a general conflict, is one between privacy and speech, and particularly where more people's lives are now being seen online. Information doesn't disappear with an old copy of a newspaper or a book that goes out of publication. There's a greater concern about, how that information impacts people for the long term. And so you have several examples that we've seen recently of efforts essentially to remove content, particularly from the internet, but not necessarily exclusively, where publishers would essentially have to unpublish material even though it's truthful and accurate. In New York this year, there was legislation introduced for essentially what's a right to be forgotten, which is a concept imported from Europe, where they have many fewer protections for free speech and, in fact, put much greater emphasis on privacy. It would require that any inaccurate, irrelevant, inadequate, or excessive content must be removed upon request. Now, that is defined as content which, after a significant lapse in time from its original publication, is no longer material to current public debate or disclosure, especially when weighed against the financial, reputational, or other harm that the information causes to the individual who would like it removed. Now, I can say that legislation didn't go anywhere, but we don't think it's the last time that a state or the federal government will take interest in some efforts to erase information generally. And then more specifically, there's a number of states that have considered laws that would allow arrest photos specifically to be removed. Part of the problem there is there are these businesses that essentially, websites that are set up to publish mugshots and then charge somebody to have the mugshot removed. And that's the business model. So we've been pretty effective in getting that legislation redirected to focus on barring charging to have the information removed, but mugshots are frequently very important ways to convey stories, whether it's Martin Luther King's mugshot when he was arrested and wrote the letter from an Alabama jail, or Lee Harvey Oswald, or O.J. Simpson's mugshots as examples. So, those are efforts to have information removed, and then there's a number of states that are considering laws to block publication of such information. Both Texas and Illinois have consider bills to bar the publication of any picture of somebody without their consent. Newsworthy, not newsworthy, it doesn't matter. If you publish a picture of somebody without their consent, it's a criminal violation, and they can request that it be removed. Montana considered a bill that would bar publication of an image of a fatal auto accident if the deceased person is identifiable and their next of kin has not yet been notified. It's certainly a reasonable interest in privacy, but you can't bar news publishers from publishing an image of an auto accident, for example. And then finally, there's lots of legislation that bars any publication of nude images of any kind, for any reason, any time. They can be historical, educational, newsworthy, artistic. If you don't have the explicit consent of the person depicted, you couldn't publish the images. So images from the prison in Abu Ghraib, the images of Anthony Weiner, for example, all would be subject to criminal sanction. And then finally is the use of tort law to chill speech. The most obvious example was the lawsuit against Gawker by Hulk Hogan. They use a particular tort, the publication of private facts, to get before a jury, and it's a very sort of common practice among juries to punish news publishers. They don't like them, and they like to impose damages. Unfortunately for Gawker, they couldn't afford to maintain the lawsuit, even though they likely would have won in an appellate court. Another example is the use of right of publicity. The right of publicity says you can't use my image in an advertisement for Coke or McDonald's without my permission, but it's very common to see lawsuits. I mean, an example would be a soldier who sued Mark Bowl, the author of the article Hurt Locker, as well as the screenplay as well, and he sued Playboy, who published the original article, as well as the movie company. And that case went on for several years. He ultimately lost, but there was no question that that was not a commercial, an effort. It wasn't an advertisement for anything. It was telling somebody's story, and you don't have to get somebody's permission to tell their story, whether it's flattering or unflattering. And then finally, I'll bring up an example, because this one's been in the news a lot, and the Trump administration does keep coming back to this point, but there was a bill enacted in Texas this year to make it easier to sue publishers for libel, publishers and authors for libel. By the major distinction in libel is whether or not somebody is a public figure or a matter of public concern. There's a much higher standard of proof, at the actual malice standard, to win if you're suing in that case, if you feel you've been libeled. And this Texas legislation would want to make that a jury question rather than a question of law, so the judge decides it. And again, in large part because juries are much more inclined to punish authors, writers, journalists, news publishers, and the like. So again, that bill didn't actually pass, but it's a blueprint for other states to consider, and potentially the federal government to consider. Now, that law is established by the Supreme Court and the First Amendment, and likely those laws would be struck down, but it is still, legislators looking at ways to, as they say, open up the libel laws to allow plaintiffs to put greater pressure on publishers, and particularly impose financial pressure on publishers by making them defend these lawsuits. So anyway, those are some examples. I'm happy to talk about other legislation or any particulars about this legislation if you'd like, Mary, but I'll leave it there.
Okay, David, thank you very much. That was a lot of information very quickly, so really appreciate your summarizing so much so quickly. I have a couple follow-up questions around the issues of defamation and right of publicity and how they can sometimes bump up against free speech and the types of cases that we're seeing around those. So it might be interesting for you to talk about either the Lowen case or the Tabanek case as the first issue in terms of how, right of publicity, why it's important to limit right of publicity and the ability to use the right of publicity claim. so that it doesn't impinge on free speech and the right to talk about, the free speech right to talk about individuals in an informational way as opposed to a commercial way. And then I want to ask another question about defamation, because we do have a president who has said that he would like to strengthen the libel laws.
Sure, and I guess the overview, both with you know, particularly with right of publicity, but also, you know, as was the example in the Tobenik cases, commercial speech gets much less protection for under the First Amendment. It gets a different standard from what we call non-commercial speech. Now, commercial speech is limited to speech that is essentially an invitation to an economic transaction, is what the lawyers say, which is a fancy way for saying advertising. I can't use you know, Lindsay Lohan's picture in an advertisement for a product. However, I can write a book about Lindsay Lohan as a biography. I can use Lindsay Lohan as a character in historic fiction, for example. I can make a movie about Lindsay Lohan, and it can be very unflattering, and it's very much protected by the First Amendment. So the Take-Two case, Take-Two is the makers of Grand Theft Auto. One of the iterations of Grand Theft Auto uses there's a character in the video game who Lindsay Lohan feels has sued, accusing Take-Two of using her image and her likeness and her personality. This character is her, and you know, essentially, they are allowed to do that absent them doing that in a commercial. You know, they can't make a video game that's a commercial for a product other than the video game itself. For you know, for Coca-Cola or McDonald's or what have you, that in that case she has those rights. But there's a lot of pressure. There's a lot of attempts to try to shoehorn speech into what is considered commercial speech. And the Tobenik example is the same. Dr. Tobenik has a medical clinic in Florida. Some of the treatments he recommends for Alzheimer's and other conditions are not generally accepted practices. Dr. Novella is a professor at Yale who has a blog that likes to write about, you know, he likes to write about procedure, you know, what he thinks is quack medicine. He did so about Dr. Novella's treatments. Dr. Novella sued him, and he claimed because there was advertising on Dr. Novella's website, and you could buy products on buy T-shirts and so forth on Dr. Novella's website, that this converted the speech, the article, the blog post criticizing Dr. Tobenik into, you know, from non-commercial speech into commercial speech. You know, it was a fairly ludicrous argument, and the courts treated it as such. Although it looks like Dr. Tobenik may try to seek cert with the Supreme Court. But you know, in both cases, for example, the First Amendment for non-commercial speech is a very high barrier, whether we're talking about right of publicity or, you know, other torts like this. And non-commercial and commercial speech is given much less protection. So you see these efforts by plaintiffs to shoehorn speech into the commercial speech area, and therefore make it much easier for them to succeed. So you know, those are a couple of examples that we've been involved with, a couple cases that are ongoing now, and I think in both cases probably have gone farther than people think on the merits they should. But that's, you know, that's part of the problem. Another example, well, we can get to it in a second. I mean, there's it's more of a defamation case, so I'll leave it for now. But I hope that answered, you know, and that distinction is an important one, because, you know, most of what's written, film, produced, is non-commercial speech, and therefore gets the highest protection under the First Amendment. And any chipping away at what we deem to be non-commercial speech is a significant threat.
Right. Thank you, David. That's helpful. I do want to talk a little bit about how authors can protect themselves. A question we get from many of our members when they're writing about real people is, will I get sued writing about this? So one, it's helpful to understand the distinction between commercial and non-commercial, and that when you're writing a book about somebody, that's non-commercial, right?
Absolutely.
And then there are always concerns about defamation, and we won't go into defamation law in this webinar today. We've done other seminars specifically on defamation and what needs to be proven there. But, one concern that we've heard from some of our members is, well, first, Trump has said he wants to strengthen the libel laws to make it easier for plaintiffs, and is that a possibility? But the other issue is something that you touched upon, is that the law is, open enough so that plaintiffs can bring lawsuits even if they're kind of ridiculous, even if they won't win in a court. Or, it's highly unlikely they're going to win in a court because they're trying to shoehorn non-commercial speech into the commercial speech area or whatever. And most authors cannot afford to defend those lawsuits, right? So perhaps they have a publisher who's willing to take on the expense of it under the contract, but generally speaking, the author still has to pay the deductible for insurance. So it can be very, very expensive. And we have seen, Trump himself has bragged about bringing lawsuits against journalists and authors as a way of, getting them to back down because he says he can, crush them. This was before he became president. But he did.
Yes, and he has done this. I think there was a reporter for Business Week who wrote a book about him and claimed, and this was maybe 10 or 15 years ago, but claimed he was worth much, much less than he's always claimed. I think he pegged his net worth about $450 million, and President Trump sued him, and eventually, it was not dismissed in the district court, and ultimately was as the appellate court reviewed the case. But it was an effort to financially punish both the reporter and the publisher. The publisher, did defend, and they did ultimately win. But it's certainly it's a practice, and I think the Gawker, what happened to Gawker is not exactly defamation, but an example of attempting to financially punish a publisher who wrote unflattering things, not even about in that case, the plaintiff, but about somebody funding the plaintiff. So it is an issue. The first thing I can say is maybe the best thing to do is to be an author in the state with a strong anti-SLAPP law, which allows the dismissal of a case at a very early stage and would minimize the financial cost. But it's very difficult. It's almost impossible to keep a plaintiff, particularly a deep-pocketed plaintiff, out of court. And that's and that issue. There's on the one hand, it's a problem, and in anti-SLAPP lawsuits, there is in some states, prevailing party can obtain legal fees. So there is a disincentive to those kind of lawsuits. But not every state has an anti-SLAPP law, and they're a mixed bag. Some are much better than others. There's a lot of interest in a federal law that would allow, that would be helpful in any federal court. And as you know, as a lawyer, you can remove the federal court, assuming you have constitutional interests or diversity of citizenship. But the bill keeps almost passing and then not quite passing. So it hasn't been a priority so far this year, but that's an example of legislation that many on the right and left are interested in. Sometimes it's those in the middle that hold these bills up. So, but it's difficult because access to courts is also it's a constitutional right and one that we would be equally sensitive about, in that you don't want to deprive people from the right to the courts. It's difficult to parse denying the right to access to courts and stopping frivolous lawsuits.
Right. So thanks for that. So do you see any potential for federal legislation on libel law, or, including anti-SLAPP law? But in other words, is there anything to President Trump's statements that he'd like to, strengthen the libel laws? Given that they're state law, is there anything that could be done there during his administration?
Well, I would say in Congress, I think it's unlikely. I'm not sure there's a great appetite among, the members of the House and Senate to get engaged in this kind of legislation. For the most part, libel law is constitutionalized. So you can't pass a law that changes the standard for that would change the actual malice standard to make it easier for plaintiffs to prevail. The Supreme Court has indicated that that's what that's what the rules are, and you can't by legislative fiat just change that standard. Now, I offer this caveat. It doesn't mean that some legislatures, whether in the states and occasionally in Congress, don't ignore what the Supreme Court has said and pass laws anyway. But I don't see at this point anything in the federal legislature. States are a very different story, and we see very odd things that come out of the states. And in particular, this this bill in Texas was an example. The legislator also introduced a bill that would prevent anybody who had given a campaign contribution in the previous 5 years, any reporter who had given a campaign contribution in 5 years or worked for anybody who did, would no longer benefit from Texas shield law to prevent reporters from having to give up their sources, for example. So we see all kinds of wild legislation in the states, so I wouldn't rule it out there, but I don't think there's a great appetite for it in Congress. The real place that President Trump can have a greater influence is on his selection of judges, and in particular Supreme Court justices. Everything I've read about now Justice Gorsuch suggests that he's very strong in the First Amendment, and there's no reason to think that he's inclined to roll back what the Supreme Court has said about on libel law, the protections for speech in the context of libel law. But he's also written very little, so we will see.
Okay, thanks, David. So I think now we will move on to some general questions for all three of you. If anybody is on the line, has a question, please forward it to us now. I think it would be helpful if the three of you could talk about what you do on a day-to-day basis to address First Amendment concerns. How do you in your daily work go about bringing attention to issues? I mean, David, you've just spoken a lot about a number of cases that you've been involved in, but exactly what is your work to ensure that the First Amendment remains protected, and what are the challenges? I know it's a very open-ended question, but do one of you want to take a stab at it?
Well, I go to Media Coalition meetings, and I read everything that Joan sends me. And
that might be commercial speech, Chris.
Yeah, there is a small, I referred to the fact that there are a handful of groups that focus mainly on free speech, and we all network through something called the Free Expression Network and share information that way. So a lot of what we do is track the issues that our friends and allies are working on, so that we know what's going on, and when possible, we join in statements. And Joan probably would want to say something about the fact that NCAC often takes a leading role in drafting statements on things like dangerous, and we also did a statement on the Trump administration's attack on mainstream media. So that that's very important. The scope of First Amendment now is so wide. There are so many parts of it that it's a big part of our job to just keep track of that. What I do at the Booksellers for Free Expression is a combination of advocacy and education, on behalf of booksellers who are running into problems that are First Amendment related, whether they're being criticized by a customer for carrying a book or for not carrying a book. What's the best way to respond to that? We often author events by controversial people often cause booksellers a lot of headaches and can be quite panic-inducing because they become the focus of some intense protests. We help the booksellers walk through those problems and avoid the danger of their possibly canceling an event and creating a bad precedent. One of the most recent cases in which we've intervened on behalf of a bookseller was a bookseller in Saugerties, New York, who decided that he was going to draw attention to what he saw as the parallels between Nazi Germany and the Trump supporters by putting a Nazi flag in his window along with a bunch of books about the rise of Nazism. And Saugerties is a upstate New York rural town, tourist area, and the town fathers and mothers decided that they wanted this flag taken down, and they hit him with a couple of zoning violations, at which point I turned to Dave and to Media Coalition to advise the bookseller about his constitutional rights, and they got involved and got the town to acknowledge the problem and to withdraw the violations. And then the other big thing that we work on a lot, there is only one national celebration of the freedom to read, and that's Banned Books Week. And in recent years, Banned Books Week is now, it started in the early 80s, and we have been working to bring it into the 21st century, working to build up its impact through social media and other initiatives, and we think that's very important for booksellers. It is their most popular promotion practically throughout the whole year. They get a tremendous response to the displays of books that people had no idea were ever challenged. People walk in and they see these displays and they see their favorite books from childhood, young adulthood on these books, and they're just it drives home to them the message that free speech really continues to be a contentious issue in this country, and asks for people's support. So that's my day.
Okay, thank you. I think will date me in terms of my age, but I remember when I was in middle school or beginning of high school, and Are You There, God? It's Me, Margaret, Judy Blume's book was first published, and it was sort of a life-changing book for my friends and I, and I later found out that that was one of the most commonly banned books. So, which I hadn't realized at the time, because I guess I didn't live in a jurisdiction where that was deemed where there was a lot of book banning. You know, Joan mentioned that the fact that there is so much book censorship that people just aren't aware of, and I think, you know, it's a really interesting issue is how to create public awareness of banned books, and Banned Books Week is obviously a very, very good way to do that. I think it's one of the things that your organizations do very well is try to increase public knowledge of the fact that there still is book censorship. But Joan, I wanted to ask you about some of the work that you guys do to promote First Amendment rights and to bring attention to book censorship.
Right. Well, we do work on a couple of different levels. Chris indicated we do work on the national policy level to sort of articulate positions and organize different groups to join together to take a position, to make a statement, to coordinate a campaign. And we have our own coalition. It has 55 national nonprofit organizations, and in addition to which we coordinate the Free Expression Network, which is a different group of free speech advocates. The National Coalition Against Censorship is composed of groups drawn from all sectors. There are religious groups, there are labor organizations, educational groups, and so on. So it's not just civil libertarians, whereas the Free Expression Network is a network of organizations that work specifically on one of many First Amendment issues. But I also want to talk about a different aspect of our work, which is that we work with individual writers, teachers, students, parents, school administrators, you name it, around the country whenever there's a book censorship incident in a local community. And we frequently get calls from authors who have found out that their books have been challenged, and they ask for our help, and we then contact people in the school, and we try to assist in whatever way we can. In many of these cases, we will write a letter to the local, either the school superintendent, the principal, the superintendent, or the school board, depending on who's involved, and try to help them understand their obligation under the First Amendment not to remove material just because somebody in their community doesn't like it. And we have a very good track record in getting school boards to be more respectful of the fact that they serve a community with a wide diversity of views, even if there are some people who are noisier than others and more insistent than others. And as we often point out, their chances of being successfully sued by a disgruntled parent who wants a book out of the school is slim to none, whereas their chances of being successfully sued if they take a book out that is educationally valuable are much greater. So, you know, the law has these principles embedded in it. Most people who work in school districts from the teacher level up to the school board don't necessarily know what that law means or how to apply it. And, you know, we hope to be helpful to them in understanding what their legal obligations are. So I would say at least 50% of our work involves working in local communities around the country, and we work on not just book incidents, but also art censorship incidents. And, you know, just this week, there's a new challenge to Rainbow Rowell's book, Eleanor and Park, in Ohio, and a new challenge to Absolutely True Diary of a Part-Time Indian by Sherman Alexie in Idaho, and that's sort of the bread and butter kind of thing that we deal with.
Great, thank you, Joan. David, do you want to add anything? You did talk a bit about the types of litigations that you get involved in.
I guess I would say just briefly, I mean, on the legislative side, we monitor all 50 states and Congress. If we see legislation that's a problem, we work with our members who may have people in the state, in the Capitol, as well as other members who may have grassroots support, whether it's booksellers and librarians, as an example, to try to stop the legislation. We inform legislators that that a bill is unconstitutional for whatever reasons, and we do everything we can to build a coalition to oppose. In the event the legislation is passed, that's when we would then consider a challenge. And over the 40 or so years Media Coalition has been around, we've done at least 35 to 40 challenges where we've gone into court and sued because the law violates the First Amendment with, not to pat ourselves on the back, but with a very strong record of success. In fact, we're just winding up a litigation in Louisiana where they passed a law that said any website that has any material, any sexual material that's inappropriate for minor, has to age verify everybody who comes to the website, which typically drives away many people who would come to that kind of content, who don't want to give up their name and age to verify that that's what they're looking at. And on our concern, so we sued and we won in the district court, and the state of Louisiana decided not to continue the lawsuit. But in that case, we work together with our members who are willing to be plaintiffs in the lawsuit. We bring the challenge. And then in addition, if there's important cases, we also would then look at writing a friend of the brief court, cases we didn't necessarily initiate, but we think have a significant impact on the media that's represented within Media Coalition, including authors and booksellers, book publishers, librarians again. So that's some sense of that, but most of my day is staying up to date on what's going on in the various states, drafting letters and memos on the legal issues, and then working with our lawyers, depending on where we are in litigation, and what in discussion of cases we might bring and where we are with cases we are currently involved with.
Okay, great, thank you. We do have a question from a participant, which I think is David, you'd be the best to answer. The question is about portraying a real person. Is there a difference between literature or portraying the person on stage or in film? In other words, does the media matter?
In theory, it does not matter. However, video games, there's a lot of litigation around video games, and in the context of video games, some courts have treated it differently. Video games are deemed to be fully First Amendment protected, no different than a book, a movie, a magazine, whatever other kind of content. But yet we've seen a handful of decisions recently in right of publicity cases where the video game was treated differently and damages, and the plaintiffs were allowed to prevail, even though in the context, had that been a movie or had that been a book that discussed that particular, typically they're players in sports games. So I would say in theory they should all be treated. The medium shouldn't matter. It doesn't matter in some discussion of right of publicity, and yet courts have still found sort of reasons to accept video games or treat video games differently. And the implication for all media is that we then see court cases that kind of open the door for litigation, whether it's against video games or otherwise, and also with legislation to enact the rights of publicity. So it's an issue both for the video game industry, video game creators, but also it potentially has impact on all the other parts of the media. And again, in particular, when they're writing legislation you know, there's typically big fights over which media won't be considered commercial, you know, which media is explicitly accepted within the legislation. So I guess that's a long way of saying it shouldn't matter, but yet at times it does.
Okay, thanks. But in terms of, you know, books versus film, of what I'm hearing you saying is that there really isn't a difference, like a nonfiction book compared to a documentary or a made-for-TV, you know, fictionalized version of someone's life or something like that.
Mary, I'll tell you the biggest difference. Movies often make a lot more money, and they're much more inviting targets to sue. But legally, no. There's, you know, they're not treated differently. But you know, when the movie makes $200 million, now Hollywood accounting, that means they took a loss. But you know, when you see in the newspaper, oh, it made $200 million, and I'm a character, I'm going to sue. So maybe I guess what we should hope for is that books start making $200 million each, and then we'll see how it goes.
Hear, hear. Exactly. So, okay, well, guys, we have only 2 minutes left, and there was one topic that we haven't gotten to, which I just want to mention, because we are hearing more and more about it, and we are planning on doing some kind of panel on it, maybe this summer and the fall. And this is the new phenomena, relatively new phenomena, at least we're only hearing about it recently, where authors their manuscripts are sent out to sensitivity, quote unquote, readers. And this particularly pertains to young adult books being sent out to people where there are issues of, you know, gender or race or sexuality, where, you know, outside readers are hired by a publisher to comment on the book. And we've heard from some authors that this feels like a form of censorship to them. So with, you know, just a minute left, if any of you want to jump in and say anything about that, please do so. Otherwise, I'll just tell the participants, the audience, you know, stay tuned.
Well, I would just to say that there's plainly the potential that sensitivity readers could be used to avoid publishing controversial content. It's not entirely impossible that they could be used to improve a text. It's a very complicated issue, and I'm delighted to hear that you're going to hold a panel on it, because it badly needs to be explored, I think. And I think that publishers have been under attack recently, and they might perceive this as a way to avoid future attacks, but only at the cost of trying to avoid controversial topics.
Yeah. Thank you, Joan. Agree, it is a complicated topic. So with that, more to come. We've got some more panels with Copyright Clearance Center coming up in the coming months, and we'll be sending out information about them. I want to thank Chris, Joan, and David very, very much for your participation today. We really appreciate it. And to everyone in the audience, we appreciate your participating today as well. Have a good afternoon, everyone.
Thanks, Mary.